Hello, my name is Ellen Schwartz, and I am the Director of Legal Resources for the Middlesex County Family Justice Center at Women Aware. This Law Series video project is co-sponsored by the New Jersey State Bar Foundation and made possible through funding from the IOLTA Fund of the Bar of New Jersey. In this video, we are sharing information about restraining orders. What is a restraining order, and how will it help me? A restraining order is a court order directing your abuser not to have any contact with you. This includes in person, by telephone, by email, by text, or even having someone else contact you with their request. If you live together, the abuser will have to leave the home and reside elsewhere until the case reaches a final conclusion. The judge can also order some temporary financial assistance, such as mortgage, rent, insurance, child support, and can award custody of children on a temporary basis. The police must arrest the abuser if they see visible signs of injury on the victim, such as bleeding, scratches, or bruising. What is a TRO? What is an FRO? A TRO, or temporary restraining order, is given to an individual who is seeking the protection of the court if they qualify. A TRO will usually remain in place until it is dismissed by the victim or until the next court hearing. That hearing is usually scheduled within 10 days. At that time, the victim can request an FRO, or final restraining order, or dismiss the TRO if they so choose. If the court enters an FRO, that order is permanent unless it is dismissed by a judge. Restraining orders do not expire in New Jersey. They are good forever. How do I know if I qualify for a restraining order? Domestic violence restraining orders are controlled by a statute called the Prevention of Domestic Violence Act. There are two parts. You must have a qualifying relationship with the abuser, either married, living together, or previously lived together, have a child in common, dating or previously dated, family member, roommate, or caretaker. Generally, the abuser must be 18 years of age or older to be charged with domestic violence. The second piece is you must be a victim of an act of domestic violence. There are 19 specific acts listed in the statute, which you can review online. The most common ones are assault, criminal trespass, criminal mischief, and harassment. Where do I go to get a TRO? To obtain a TRO, you must go to the Middlesex County Family Courthouse at 120 New Street in New Brunswick between 8:30 a.m. and 3:30 p.m. on regular weekdays. You will meet with a domestic violence hearing officer who will make the decision about whether or not a TRO should be entered. You should tell that hearing officer everything that happened, as well as any previous acts of domestic violence, even if they were unreported. Providing a history is helpful in setting the stage for your final hearing later on. Outside of regular work hours, you can go to your local police station and let them know that you want a TRO. They are obligated to get the emergent duty judge on the phone, and you can explain what happened and why you want the TRO. If I get a TRO, what happens afterwards? If you get a TRO, you are now designated as a plaintiff, the person bringing the action. The abuser is now designated as a defendant and must be served with a copy of the complaint and the TRO. The sheriff or the police must do the service on the defendant. Keep the TRO or a copy of it with you at all times. Make multiple copies if you can. Once you have the TRO, a final hearing will be scheduled within 10 days or so at the courthouse. If you want to dismiss your TRO, you can do it then. If you want to proceed and ask the judge for an FRO, final restraining order, then you will have a trial. You and the abuser will both have the chance to testify before the judge and explain what happened. You must bring with you any evidence that you want the judge to look at, and you must also bring any witnesses that you want the judge to hear from at that time. You may want to consult with an attorney prior to the trial, and if you feel that you can benefit from legal representation or legal counsel, that is encouraged. If you can't afford a private attorney, we can try to help you obtain an attorney who will provide free legal services. This should be done as far in advance of the trial as possible to give the attorney a chance to review the paperwork, meet with you, and get up to speed on your case. Who are legal advocates and what do they do? The legal advocates work for Women Aware. They do not work for the courts. We have legal advocates in court every day that the courthouse is open. They can be reached through the Domestic Violence Intake Office. Although they are not attorneys and cannot provide legal advice, they are very knowledgeable about the domestic violence process. They can help prepare you for your final hearing. They can both inform and help you evaluate your legal options. They can explain the specifics of the hearing process to you, and they can provide you with emotional support throughout the hearing process. If you decide to dismiss your TRO, they can assist you with that as well. What is a final hearing? A final hearing is also called a trial. It is the proceeding where a judge will decide if your TRO should become an FRO. In addition to your testimony, this is your opportunity to provide the court with any evidence that you might want the judge to see. Photographs, text messages, which you should copy and print, handwritten notes from the abuser, medical bills, repair bills for damaged property, etc. The court will not look at items on your phone. Print them in advance if at all possible. If you want to show a video, it's important to remember that you must bring your own laptop or tablet. You cannot enter any media into the court's computer system. You will have the right to call witnesses. The witnesses should be limited to individuals, not your children if at all possible, who saw or heard the incident of domestic violence and can share with the court what they saw or heard. The judge will be looking at whether or not you need a final restraining order to protect yourself against further harm, trying to assess if you are still in fear for your safety. What if I don't want to get an FRO? Can I dismiss my TRO? You always have the option to dismiss a TRO. The judge will ask you questions to make sure you're not being forced or threatened into dismissing. We encourage you to meet with one of our legal advocates prior to taking this step for two reasons. She can discuss your options with you, and if you choose to proceed with the dismissal, she can assist you with the process. As a reminder, dismissing the TRO has no impact on any criminal case that might be pending. There is a third option. If you don't want to proceed on your final hearing, but you and the abuser have reached an agreement on some or all of your issues, you can enter into a civil consent order. Our advocates can provide helpful suggestions as to what issues can or should be addressed in a civil consent order. Thank you for joining us. Please make sure to watch the second portion of our video series on restraining orders, where we discuss civil consent orders in more detail.